Well, good morning and welcome everyone. My name is Rebecca Goldfrank. I'm with Children's Law Center. Welcome. This is the Custody Guardian Ad Litem training, and we're grateful to see you all here this morning. I am, unfortunately, our pro bono director, Nancy Drain, is not able to be here today. I know she would have loved to be here to meet all of you. But she will be your primary point of contact regarding any interest in taking a pro bono case. And you will hear from her going forward as you'll receive our emails regarding CLC's work. So just briefly, I'll give you an overview of our pro bono program and the work that Children's Law Center does. Children's Law Center, CLC, is the largest civil legal services in the District of Columbia. We helped over 5,000 children last year through our pro bono program and through all of our in-house staff attorneys and our policy team. We have several programs at CLC. The largest program is our Guardian Ad Litem program, which is not to be confused with the reason that you're here today doing custody Guardian Ad Litem work. That is where the attorneys at CLC are representing children in the abuse and neglect system, and that's not the work that we're doing here today. But that is our largest program. We also have a policy program where we advocate for systemic change in the DC Council, and so that it helps children in DC. Just recently we worked closely with Council Member David Catania to put forward new special education legislation. Our pro bono program offers the opportunity to do work in three capacities. The first is what you're doing here today. That's our custody Guardian Ad Litem work, and you'll hear all about that today. The second we refer to as our caregiver representation work, and that's where attorneys represent third-party caregivers, so foster parents, grandparents, aunts, uncles, other caregivers of children, with the goal of getting those children out of the foster care system or preventing them from entering the foster care system. So we're talking about children who are living at risk, and we are providing what we call a permanency option for them through custody, adoption, guardianship work. And that is a great deal of, it entails litigation and court appearances and representing a stated interest caregiver. The third kind of work is special education advocacy, and that's through our Healthy Together program, where we have a medical legal partnership, and we have several attorneys who are co-located at clinics throughout the city of the Children's National Medical Center and the Mary Center, and we have folks who the doctors make referrals to the attorneys there, and they identify some need of the child that's preventing the child from receiving appropriate education. And so there are opportunities to represent the caretakers of those children to help secure appropriate educational services. In terms of eligibility for taking a pro bono case, you don't have to have prior family law or special education experience. We ask that you come ready to learn those areas of the law, but no prior experience is actually necessary. You do need to be admitted to practice in the District of Columbia, or you can be eligible to practice under the DC Court of Appeals Rule 49. So there's several criteria, and many folks will meet that you will be practicing under the supervision of another attorney, or if you practice in another state, and you can practice in DC pro hoc vice. But certainly Nancy is always willing to talk with you about whether you are eligible. And there's a helpful handout in the manual That is the pro bono FAQs, and you'll have hopefully be able to get answers to any questions related to eligibility in there. There are obviously lots of benefits to taking a pro bono case with CLC. I think the opportunity to work with our clients is often an amazing opportunity, and you are making a difference in the life of a child in the District of Columbia. Our case placement procedures. So many of you may have cases already, or now you are signed up to receive our newsletter. We also have a list of available cases that is in the manual. Yes, in the manual today. So if you're interested in a case, you can email Nancy Drain, or you can let me or Jillian Chaps, who checked you in front, let us know if you are interested. We wouldn't place it with you today, but if you have an interest, you can certainly let us know. And then you will hear from Nancy or Jillian about the availability of the case, and you will receive, once we decide to place it with you, you will receive an email with the case information for you to run conflicts checks, and we will also provide you with all of the sort of information that you need to get started with taking a case. CLC is always available for mentoring and supporting you once you have a case with us. You will find great materials in the handouts today. By the end of the day today, we will also have those materials on a CD. And we have model pleadings and training information on our website that is open and available for you to check out. Additionally, we do have some other pleadings that are available through one of the mentors at CLC. I am a mentor, and several of the other people who you will hear from today are also mentors. And we can be available for conference calls. We could certainly sit down and meet with you and talk through case strategy. We're also available to have a look at some of your pleadings, to talk about any kind of case strategy issues, or even the very simple procedural questions that you may have, because we know that you're not necessarily familiar with taking on one of these cases. So you should feel free to contact us at any point. So our agenda for today's training, we will first talk with you about the role and practice of being a guardian ad litem. And then we'll talk with you some about cultural competency, as that's a necessary component of this work. We have a short break. We'll then provide the law regarding custody and civil protection orders in the District of Columbia. Lunch will be provided graciously by Cooley, and the lunch will be a short break because at 1 o'clock we will have Judge Peter Krauthammer who will speak to us regarding providing a view from the bench and talk to us sort of about best practices. After that, we will hear from a staff social worker at CLC regarding some of the important kind of clinical issues that you just need to be aware of in this practice. So communicating with children, because you will have a child client. Domestic violence, signs and symptoms, abuse and neglect, and touching on some issues around substance abuse. We'll then talk about some CGL case hypotheticals, and we'll talk about, lastly, presenting evidence in custody cases. We do ask that you complete the evaluation that is actually in the back panel of the manual by the end of the day. We take your feedback seriously and want to make sure that the training experience that you have and future pro bono attorneys have is as meaningful as possible. I welcome any questions as we go through the day. I know that some folks here do have cases already. So, your experience is helpful, I think, for other folks too, and it makes it a more fun day if we're interactive. So, next, Marissa and I will be talking with you regarding the role and practice of being a guardian ad litem. And Marissa, this is Marissa Gunn, our colleague. She's a supervising attorney at Children's Law Center. And we'll get into the nuts and bolts here. Okay. So in the District of Columbia, guardians ad litem are attorneys. They must be attorneys. They're appointed in basically two types of cases, which I alluded to earlier. So there are abuse and neglect matters, and those are cases wherein the state has inserted itself into the family. So the state has taken an action to remove the child from the family. And the second kind of case, which is the kind of case that we are dealing with, are private custody matters. So very rarely is the state involved, at least not to that extent. And our private custody matters are sometimes referred to as DR or DRB matters. The government does not initiate the case. The case is initiated by a third-party caregiver, such as a grandmother or someone with standing to file for custody, or a parent. The court has the authority to appoint a disinterested attorney to appear on behalf of the child and represent that child's best interest. So this is not a stated interest role. This is a best interest role, and we'll talk more about that. In late January 2014, the court, through an administrative order, issued practice standards for guardians ad litem in custody and related consolidated cases. So those are very important for you to review, and they are provided in the manual as well. And I should have said, and I apologize, but it looks like most of you have found this, in this manual, the PowerPoint slides are in tab 5 through 11. So we are currently in tab 6. The DC rules of professional conduct apply to guardians ad litem. That's also clear in the practice standards. And SS versus DM is actually a case arising in the neglect context, but it affirmed the principle that an attorney, including a guardian ad litem, should not serve as an advocate and a witness in the same proceedings. So what are our responsibilities as GALs in custody matters? We have to represent the child's best interests in all facets of the case. We investigate the child's custodial arrangements, and so that means we are assessing every potential home environment or visitation arrangement that the child may have. And our responsibilities are ultimately to form a position and advocate for the child's best interests. This is not something we just pull out of thin air. There's statutes that guide us in determining what the child's best interests are. These two statute sections, the first one is often referred to as the parent-parent custody statute. So these are cases between parents. The second statute listed is what we often refer to as a third-party custody statute. It's also called the Safe and Stable Homes for Children and Youth Act, and that was a law that was passed in 2007. There are also useful practice pointers that you will find in tab 1 of the manual that will be on a CD later today, not this manual.
So the court could decide to appoint a guardian ad litem for a variety of reasons. And as Rebecca mentioned, guardians ad litem are not automatically appointed for these custody cases. So oftentimes there's some specialized reason why the court thinks that the services of a guardian ad litem might be helpful on the case. So one very broad reason the court might decide a guardian ad litem might be useful is to just help the court reach a decision regarding what custodial arrangement is going to be in the child's best interest. And the GAL would help with that very broadly by conducting an investigation and assisting the court in obtaining information and objective evidence about what decision is in the child's best interest. And the guardian ad litem, in addition to presenting that information to the court through witnesses and documents and all the other ways that any other attorney would present information, the guardian ad litem can also make a recommendation, sort of the way that other parties do, but for various reasons, when a recommendation comes from the guardian ad litem, oftentimes the court will view it as more unbiased and more objective than when it comes from the parties. The court might also want a GAL to help facilitate communication between the parties. Because of the nature of these cases, it's really not uncommon for you to have two parties on a case that really do not get along, especially when it's two parents that perhaps used to be in a romantic relationship. Perhaps there's also a related divorce proceeding. But for a variety of reasons, a lot of times there are huge communication breakdowns. And the GAL can be helpful in facilitating that communication. But it's important to keep in mind that it's not your role to simply say, well, this party says this, and then you take that information back to the other party. It's really about helping the parties find a way to better communicate. Maybe they don't ever need to talk on the phone because that's just always going to break down and result in fighting. Maybe they need to start keeping some sort of journal. Maybe email is better. It's within the role of the GAL to help figure out what's going to make communication better so that once the case is closed, either through settlement or trial, these parties can move forward with their lives and hopefully they can co-parent the child effectively. The court might look to a GAL to help facilitate mediation or settlement, either formally through the court's mediation center, which I think will be talked about a little bit later, or informally, just between the GAL working between the parties to broker some sort of agreement. The court might just be looking to access information about the child and the child's opinions. Once we start talking more about the statutes, you'll see that one of the factors that the court is required to consider is the child's wishes. And so oftentimes the court is looking to the GAL to help provide the court with a sense of what it is the child wants, so that the court can fully consider that factor. And oftentimes where that is a primary sort of role that the court is asking the guardian ad litem to take, the court is also looking to the GAL to help prevent any harm that might come to the child from the child testifying. And we'll talk a little bit later about the ways that the GAL can get information about the child's wishes before the court without the child testifying. The court sometimes also would like the GAL to help present to the child a more objective version of the custody matter. In these cases, a lot of times parents and third-party caretakers really do have the best interest of the child at heart, but they're also dealing with a lot of their own emotions, and I'm sure many of us are aware that sometimes that makes it hard for us to make the right decisions in a particular situation. So a guardian ad litem can be useful in helping sort of explain to the child in an age-appropriate manner what's going on, what the custody case is about, and what's going to be happening moving forward throughout the court process. Sometimes the court is looking for a very limited role for the GAL to serve, just in determining whether or not a child should testify or just in helping the family locate therapeutic or other types of services. And other times the court might appoint a GAL when they suspect that one parent or another party is using undue influence on the child. So if the parties are saying, one party is saying this is what the child wants, another party is disagreeing, but for some reason it becomes clear to the court that some party is either talking to the child inappropriately about the case, maybe trying to bribe the child with material things to get the child to say certain things. At that point, the court might think a GAL is helpful to figure out what the child's true wishes are, aside from the parties sort of trying to convince the child to want certain things. And lastly, the court might appoint a GAL if there are very specialized medical or mental health concerns, maybe there's a child with a very serious disability, and the court needs more information about that in order to make a decision in the child's best interest. So these are just a couple of reasons why the court might appoint a GAL. They could be different in your case. There could be multiple reasons in your case, but these are some very common considerations that the court will look at when deciding whether or not to appoint a guardian ad litem.
And we should say that in the practice standards, there are, I think, 15 enumerated reasons or situations where it might be appropriate for a judge to appoint a guardian ad litem, and then there's a catch-all provision that basically they can appoint a GAL whenever they would like a GAL. The tricky part is that there's no funding stream for guardians ad litem in custody matters, and that's where you all come in, because frankly, most of the cases that we're working on are dealing with folks with limited means, and so while there are people can pay for a guardian ad litem through private attorneys, you all are the real source of GALs in the District of Columbia in custody cases. So the responsibilities of the guardian ad litem. The GAL, pursuant to your appointment order, is to have the rights of a party. The GAL should be independent from the court and the other participants in the litigation. So the GAL should form a position based on the GAL's independent investigation, and fully and freely participate in the case. The GAL must be a zealous advocate per those ethics rules for the child's best interests. So as we said, an attorney cannot serve as an advocate and a witness in the same proceeding. So the GAL shall not testify, but shall offer traditional legal-based, evidence-based arguments, exhibits, and witnesses in accordance with the laws of the District of Columbia. Sometimes there's confusion around this issue, but it's very clear the GAL is an attorney and should put forward evidence just as counsel for the mother or counsel for the father would do. You should make motions, evidentiary objections, file responsive pleadings, and you have an obligation to preserve issues for appeal on behalf of the child. And the GAL should not prejudge the case. When you get a case from us, you will receive what we receive, which is the case referral, and the judge may have come to certain conclusions already about the circumstances of the parties. It is your job to independently investigate that information. And it's also important, and we'll talk about this a little bit more, but to sort of set aside your own notions of how a family should be when going into these cases.
It's important as the guardian ad litem to remember that these cases are not neglect cases. They're not cases in which we can assume that one parent or another parent has already been adjudged unfit or unable to parent. And so it's important that when you're representing the best interests of a child that you're also remembering to be respectful of parental autonomy and to not impose your own personal beliefs, whether they're rational or not, onto the case. A lot of times parties might come to a GAL and ask, what the GAL thinks should happen, or even ask the GAL to tell another parent or party in the case to do something. And that's not always our role. There are times when you see a parent making a decision or a party making a decision or doing something that's against the best interest of the child. Perhaps you do want to file a motion about that. But other times, although you may disagree with the decision, it is the parent's right to make a decision. A common issue that comes up in cases can be whether or not or when a child enters daycare. Perhaps all of us would decide that it would be best for our 1-year-old to be in a daycare or a 2-year-old to be in a daycare. But not everyone believes that. You might have really good reasons about the child getting socialized with their peers for having the child in the daycare. But that's not necessarily a reason for you to sort of insert yourself in the role of the parent and try and force the court to enter the child into daycare. You could have a situation where that is an issue that's really central to the case, but it's just important to be mindful before you start taking positions on things that are not going to be sort of an immediate issue that may present harm to the child. It's important to consider the role that the parent actually has the right to play in making those types of decisions. And that said, the GAL doesn't actually have any authority to make any decisions. So during the course of your investigation, you may have an opportunity to speak with the child's teacher, and you may even have an opportunity to sit in on meetings. You might sit in on an IEP meeting. And while that may be appropriate in your case, your position in that meeting doesn't necessarily need to be put on the table. You can't sign anything, you can't authorize any services. It's really your role in those sorts of situations to gather information and to use it through the judicial system. But as the GAL, you can't actually make decisions for the child or on the child's behalf. It is important, and it is part of your role, to make sure that the child's position is somehow made a part of the record if it's appropriate. There are a lot of considerations, including the age of the child, that are going to play a role in figuring out how you're going to put the child's wishes onto the record. But know, as you're doing your investigation, that is part of your responsibilities, and it is one of the factors that the court is required to consider in making a custody determination. And later on today, we're going to talk about the number of ways that you can try and get the child's wishes known in the record, whether or not it includes having the child testify in the case. And it's important to remember that the guardian ad litem is not a mandatory reporter of child abuse and neglect. As a guardian ad litem, you may see things happening that you're concerned might be child abuse or neglect, and we would encourage you to call us at the Children's Law Center so that we can talk through some of those issues with you if you're seriously considering making a report of child abuse and neglect. But it's important to keep in mind that if you decide to take that step, there could be some very serious consequences. So it's not something that should be done lightly, and we would just encourage you to come to us and talk to us about it so we can figure out what's really going to be the best course of action in that particular case. The GAL should be sensitive to cultural, racial, and ethnic differences among the different parties in the case. And Rebecca's going to talk more about cultural competence generally after this presentation, but just be aware that we all come to the table with our own sort of biases, our own background, and our own culture. And it may be different from that of the parties that you're working with, and the parties themselves could be coming from very different backgrounds. So it's just important to sort of be mindful of that and just be aware of how it's affecting the case and how it's affecting the way that you're investigating the case and the recommendations that you're making to the court. You should conduct a thorough and ongoing investigation with an awareness as to how that investigation is impacting the parties. So for example, I mentioned that you might find yourself going to a child's school. Well, if your child client is 15 years old, maybe you don't want to go, in the middle of the school day and watch them in class and sort of try and talk to them. That could be really embarrassing. So just keep those sorts of things in mind. You want to do your investigation in a way that's going to get you reliable, important, and helpful information, but that's not going to sort of interfere with parental autonomy, that's not going to interfere with any social relationships or any familiar relationships between your client and their other family members, including but not limited to the parties.
And on that note, it may be that in a particular case, it's not even appropriate for you to visit the child at school. It may not be necessary, and it might be sort of overly intrusive into the family or the child's life. So, there isn't a checklist necessarily that you must visit a child at a certain place.
Except for the homes of the parties.
Except for the homes.
If they're visiting the homes at those parties' homes. And the GAL should monitor the implementation of court orders. As a guardian ad litem, you don't have enforcement powers, obviously. So you'll be in a lot of situations where you hear about parties violating court orders. Sometimes it's a one-time violation. Other times it's someone that consistently just refuses to follow a court order. It may be appropriate for you to continually remind parties about the existence of court orders, and even to help try and explain to them the consequences for not following court orders. So you should certainly be aware of whether or not orders are being violated, and appropriately make the court aware. That could mean that you're simply notifying the court that the order is not being followed. It doesn't necessarily mean that you're filing a motion for contempt, but depending on the situation, perhaps that is the best course of action. But you might also be notifying the court, look, the order is not being followed because it's not practical in this case. And in that situation, maybe it's helpful for the GAL to propose some sort of amendment that will be more workable for the parties.
And that raises the point that we as guardians ad litem are often having contact with the parties directly. Nearly 80% of litigants in custody matters are unrepresented. So typically we do have direct contact with the parties. When they are represented, of course, we go through the attorneys. Many times attorneys for the parents will allow us to have contact with the caretakers to the extent that we need to set up a visit or we need some information regarding the child's current welfare. But you are doing a lot of negotiation and talking with pro se individuals. And so it is important to be mindful that obviously you're not providing legal advice to those parties. But folks will ask you for legal advice. And so what we frequently do is we will refer individuals to the Self-Help Center. We will provide information to the parents. And in certain circumstances, we might, if we think it's in the child's best interest, suggest that one of the parties obtain legal counsel through perhaps another legal services organization. But that's not something we automatically would do in all of our cases.
I'm sorry, can I ask you, you're saying, by the way, Rebecca, I'm Rachel Alexander. I know we've corresponded. So you just said that in some cases you might make a recommendation that a party get counsel. So for example, in our case, now one party is represented by counsel, the other isn't. The disparity is troubling to all the legal professionals in the room, including the judge. I know mom is trying to get representation through various social services and has not been successful. Is there anything additional that we can, any additional support or resources that I can give her as a GAO?
Right.
Or
so the question was, when there's an imbalance of power and one party is represented, are there other ways that you could try to get the unrepresented party more assistance through counsel or otherwise? So there are a limited number of legal services providers. They don't just take everybody necessarily, but we could share that contact information with you. And the Self-Help Center is a good resource for folks. That is on the JM level of the courthouse. And they don't provide legal advice, but they do provide legal information, and they will sit and work with individuals and help them file pleadings and talk through their case. So those, we can certainly talk with you further about that. So in terms of getting started, when you first get a case from CLC, Jillian will send you our placement email. And attached to that placement email is a case referral sheet. And if you look at tab 18 in the manual, that is a sample, that is our case referral sheet. And so when we get it from the court, it is filled out, not always completely. We ask for individuals' occupation and some other information, but we don't always have it. And so what you get is what we get. But it does usually provide much of the pertinent information that you need to get started on a case. You'll have the plaintiff's information, the defendant, the child. You'll have a sense of the procedural posture and the current custodial arrangement on the case. We will also provide you with a sample appointment order. However, the sample appointment order that folks should use and that we know the judges are using is that the appointment order that is in the practice standards that were just issued in January. We will also provide you a sample recipe of appearance and a helpful case checklist. The case checklist is at tab 12 in the manual, and that really gives you the beginning steps and sort of some other important steps for you to keep in mind throughout your work on the case. So once you've accepted the case and you got the email from us, you should prepare the appointment order and email it to the judge's law clerk. The court will then sign the appointment order and mail copies of it to all of the parties. You are not actually on the case until that appointment order has been issued. Once the court sends it out, it's a good idea to also file a recipe of appearance. And although this seems like it might be redundant, it's helpful to have sort of the record in the courthouse file so that the clerk's office knows, because this is the way that attorneys typically enter an appearance in a case. And it also is a good way that you will make an overture to the parties when you initially reach out. So sometimes we will have write up a letter and attach it to the recipe of appearance and mail that out to the parties as an initial introduction. And that leads to contacting counsel for the parties or the parties themselves, and you begin your investigation. So sometimes folks are transient. Parents may be living in a homeless shelter or not have a fixed address, or their cell phones don't work. Keep trying. You should, I would suggest contacting folks a couple times before coming back to us. But we're also happy to talk things through to you if you're having a hard time getting in touch with the parties. On the other hand, sometimes the parties have been eagerly awaiting a guardian ad litem. And so as soon as they get that appointment order, they're calling you and want to talk with you about their case. So all of our cases are heard in that domestic relations or DRB branch in family court in the Superior Court of the District of Columbia. There are 5 domestic relations 2 calendars to which divorce and custody cases are assigned. Most often our cases don't involve divorce in addition to custody. They're usually just sort of the standalone custody matters because the parties weren't married. But sometimes that is an issue, and we will usually just monitor the divorce but not participate in it. The current domestic relations 2 judges who we get referrals from, and so you could potentially be practicing before, are Judge Epstein, Judge Krauthammer, who will be here later today, Judge Rigsby, and Judge Smith. Hopefully we'll be getting a 5th judge later this year. Yes?
I believe this is clear from the bullet point, but a case is assigned to a particular judge. It's not on a rotating, motions aren't heard on a rotating basis.
Correct.
Okay.
So cases are assigned to particular judges at the time that an initial pleading is filed. So when that complaint for custody is filed, a judge is assigned. An exception to that is that there's this 5th calendar that doesn't have an assigned judge right now. And so the domestic relations judges and the presiding judge or the deputy presiding judge of family court are sitting on that calendar, and so they're rotating. But hopefully that will clear up. Another exception is if an emergency pleading is filed. Emergencies are very rare. Those are, although I think for many folks, emergencies, it feels like an emergency, but in the court side, the circumstances are not emergencies. Emergencies are really parental kidnapping, absolute lack of contact, or a dire medical circumstance where the child will need immediate help without and a court order is necessary. There is also the Domestic Relations 1 calendar, which often involves complex divorce and custody matters where you're also dealing with a lot of money and property, and that's most often does not involve our cases.
So once you're appointed to the case and you've entered your appearance, there are a couple of initial steps that are really going to kickstart your investigation. The first is for you to request a copy of the docket and the case file from the Domestic Relations clerk. Those records should be provided to you free of charge since you are the guardian ad litem on the case. Typically, they should take about 2 business days to process those requests. So you or a paralegal or someone can put the request in. 2 days later, you should be able to go back and pick it up. Know that sometimes there is a delay and it's not ready within those 2 days, but that's generally the procedure. So once you get the docket and the file, review it so that you can familiarize yourself with the case history. Sometimes you're appointed to a case that was actually initiated several years ago and is back on a modification. So sometimes the file contains a lot of historical information that might not have been provided in the referral just for sort of lack of space. You'll also want to search for any companion or related pending pending cases. So those could include child support cases. There might be CPO cases between the parties on the case, or CPO cases just involving one or the other party and concerning another person. Sometimes there are landlord-tenant matters or criminal matters. You'll want to check to see if there are any cases involving either or both of the parties that might be important to your investigation. And if possible, you'll want to attend hearings in those cases or have someone attend that hearing for you so that you're aware of what's happening. If there's a party who has a pending criminal matter and any day now they could be locked up for 5 years, that's important to know. You probably don't want to recommend until that is actually resolved that person have primary physical custody if it's up in the air whether or not they're going to be in jail for an extended period of time. And you also want to perform background checks on the parties to see if they have any, not pending, but prior civil or criminal cases in the district or in the surrounding jurisdictions, or if you learn that someone has come from California or Arizona, you might want to try and do checks in those jurisdictions as well. There are certain types of cases, particularly domestic violence cases, that do become particularly relevant for the court to consider in making child custody determinations. Yes?
And where are the best, is the online search for other cases?
So only some cases are searchable on the online docket in DC. In DC, you can find landlord-tenant cases online, and you can find criminal cases. You wouldn't find CPOs online. If there is a related criminal domestic violence matter, you might find that, but there might also be a separate CPO matter. So you would have to go to the domestic violence clerk's office to look for the CPO cases. And the child support cases, you'll have to go to the child support clerk to look for those cases.
And for the background, it says tab 6, which we don't have, but is there information on how to do background checks?
Yes, there is. So I was just going to say, for Maryland, you can find, I think, almost all of their cases online. Criminal, you can find child support cases, divorce proceedings. There's an online search that you can do for the Maryland cases.
So there is a helpful handout at tab 6 in the CD that you'll get later today. So you can do all these remote checks, but ultimately you will, or your paralegal will need to go to these clerk's office if there's evidence there that you're going to want to introduce. So if there is a protection order in place in Maryland or Virginia or DC, you need to go get a copy of that order, and you won't be able to do that online. And for criminal matters, for example, the only admissible proof of a criminal matter is a certified copy of a judgment and commitment order, and so those you'll only be able to get from the clerk's office. But these are good sort of initial information gathering tools.
So next, as part of your investigation, you'll want to start interviewing and talking to potential witnesses and people that are familiar with the child, their family, and the parties on the case. So that would include the parties themselves. It's always helpful to have an initial conversation with the parties to get a sense of their perspective on the case, what their goals are on the case, what their what they think the problem in the case is. You'll want to meet with your client and speak with your client in an age-appropriate manner. Perhaps you want to speak with the child's teachers or school administrators. There might be a therapist involved that's helpful for you to speak with, and then family members or neighbors. It's usually helpful to ask the parties if they think there are particular people involved in the case that it would be helpful for you to speak with, and then if the child is of an appropriate age where they can tell you that, it might be helpful to talk to the child, either very directly, are there other people you think I should talk to, or sort of more informally, like who are your favorite people in life? If you have a child that spends every single weekend with a grandparent, but the grandparent's not involved in the custody case, you might not otherwise learn that this grandparent is out there and is someone that you might want to speak to regarding the case. And then you'll want to obtain other relevant, perhaps non-court related information about the child, including possibly health records, educational records, mental health information, anything that sort of comes up and seems relevant to the case. You might want to sort of try and obtain those records. You'll notice once you take a look at the proposed appointment orders that they often do include language that the court authorizes the GAL to speak with and obtain information from third parties like teachers, therapists, social workers, etc. But because we are trying to be mindful and respectful of parental autonomy, it is often helpful for you to reach out to the parents first, or the parent, whoever has legal decision making for the child. It might be helpful for you to reach out to that person to either give them the opportunity to request that information and provide it to you directly, or to ask them if they're willing to sign a release of information to access that information. The release is not necessarily required in light of the appointment order, but for a variety of reasons, it can be a little bit less off-putting if you approach it that way. And at least at a bare minimum, notify the parties in advance that you will be speaking to certain third parties about the case, or at least gathering information from those parties for the purposes of your work on the case.
And when you have a particularly time-sensitive request, such as there's an evidentiary hearing coming up or a trial is coming up, you can obviously use a subpoena with a date certain by which you need those records.
So one tricky thing that you'll need to do at some point early in the case is explain your role to the child, to your client. So once you're appointed, you'll want to promptly contact whoever the child is living with. In a lot of cases, there is a sole primary caregiver, but in some cases, the parents are sharing joint legal and physical custody, so you may be reaching out to both of them. And so if it's in the child's best interest, it is a good idea for you to explain in a developmentally appropriate age what the case is about, how the court system works, and how the proceedings are going to sort of proceed, and generally what you'll be doing as the guardian ad litem in the case. So you'll let them know that you're a best interest attorney, that you'll want to know from them what they want on the case, but that doesn't mean that you're going to go to the judge and say, this is what the child wants, so this is what they should do. You're a best interest attorney. You want to help discern the child's views about the case and report them to the court. So it's usually never a good idea, regardless of the age of the child, to just say, like, what do you want out of this custody case? And there could be a lot of important factors that contribute to the child's wishes, and sometimes the child may not actually know what they want. So it's important to really hear your questions and your conversations with your client to try and get a very broad perspective about what things most concern them in the case, about what their relationship is like with each of the parties, about what things they do in their personal life that might impact the custody case. If the child plays baseball and dad is really supportive of that, but mom is not, that's going to play a big role in what the child wants in the case, but it doesn't necessarily mean that they just don't like their mother. So it's important to have very broad conversations and really try and get to know your client and what's important to your client. And let your client know that you're going to use the information that the client gives you for the purposes of representing their best interests, but not necessarily for just advocating for what the child wants in the case.
And I think, the weight that we give the child's wishes varies in certain contexts, but it is absolutely critical that you have an understanding of the child's wishes, and they certainly do weigh into your ultimate best interest position, but they might not dictate that position. So we'll talk a little bit more about this later, or Ryan, our social worker, will talk more about talking and working with children. But there are just, a couple concepts that we want to put out at this point. It's important for you to consider the context of your role and the relationship with the child. You should not expect that you are going to have a meaningful relationship at the outset. And it may be that at your first time that you're sitting and talking with the child client that you don't really talk about much of anything other than sports or something like that. I think we have to come from the perspective that it may be that this child has suffered abuse. That's a possibility, not necessarily the case, but adults may not necessarily be protectors. So why should the child trust you? So you have to sort of think from the child's perspective on your meetings with the child. The other thing, and this kind of goes along with the idea of baseball and father favoring baseball, maybe the child has certain possessions at one home and not at the other. Possessions may have a great deal of meaning to the child. And so, when you're forming your position, you really need to keep that in mind. And we may think, if I lose those shoes or that soccer ball, I can just get another one. And that may not be the thinking of the child. So it's just important perspective. Also, you want to talk to the child in a developmentally appropriate manner, but also, take a step back. Obviously, we're lawyers and sometimes we're thinking on kind of more complex levels, but don't ask compound questions. Keep things simple. You don't want to ask a little kid why. They don't really know why. You don't want to also repeat the same question over and over. It makes the child think that they're saying something wrong, or it may make them think that they're saying something wrong the first time you asked. And so the child, that may lead to some kind of inaccurate information. And the child may have been interviewed by many folks. Maybe you're coming in a little bit later in the case. Maybe there was a Child Protective Services investigation. Maybe the child has already gone through an evaluation at the court's assessment center. That child will likely think that you have access to the information that they've shared with other people. And you may or may not have that information. But that could also lead to different stories. So just to be mindful of your context and how you're approaching the child is important.
So, like we've already mentioned, you really want to think about the age and maturity level when you're deciding what questions to ask. And this is not a list of questions to consider asking, but the responses to these questions is the type of information that you're thinking about how to obtain. So you want to know who takes care of this child and what kind of activities they do with the parent or the people that take care of them. Who's taking them back and forth to school in the morning. Sometimes it's the same person, sometimes one person drops off, one person picks up. Who takes them to the doctor either when they're sick or for routine medical checkups. Who's preparing meals. Who's present during visits with one parent or one caregiver. Maybe they live with an aunt or an uncle that you weren't aware of, or maybe one party has a fiance or a significant other that's really heavily involved in the child's life. What happens during the visits? Are there special activities that they routinely do with one of the caregivers? Or are they not doing anything? Are they playing video games the entire time? What are their favorite activities to participate in? This is all information that is going to be helpful to your investigation, and it's going to help you make a determination about what custody arrangement will be in the child's best interests.
Related to this, as I said, sometimes folks are really eager to have a GAL on a case. And so, on some visits, it may be that the child's been anticipating your arrival as well. One case that I worked on my first visit, the child, who was 12 years old, says, I only want supervised visits at the visitation center. Well, how do you know about all these possibilities in the visitation center, and what does that mean, supervised? And so, it may well be that that is an appropriate request from a child, and maybe the child does have a good understanding of these issues. But it's not uncommon for many of our kids to be feeling pressure from one parent or another to express concerns about one parent or another, or to curry favor with one parent or another. And so you just really need to keep that in mind, especially as you're talking with kids about their desires.
And it may be helpful during those initial conversations with the caregivers to make them aware, your role is to try and gather the accurate, truthful, factual information. So it might not be appropriate just to let them know, look, you're probably going to talk to your child about this case in some ways, but I don't think there's anything wrong with saying, if a child comes to me and says, my daddy said this, or, I've been talking with all these other people about X, Y, and Z, that's going to impact sort of how reliable you feel the information is. So it's not so much about making accusations to parents that they are actually coaching kids or improperly influencing, but just letting them know that that's something that you have to be mindful of. Sometimes can help parents better manage the way they're talking about cases with children, if they're talking about cases with children at all. And there are times where it's probably not appropriate for them to be having any conversation whatsoever, but we know that it happens sometimes. So making the parties aware that the way that they talk to the child about the case could impact the way that the child talks to you about the case. And so any appearance that a child has been improperly influenced is going to sort of influence how reliable you think the information is.
And it is, sometimes the kids will know that there's a hearing on Thursday, and that could be really stressful. And so, probably the parent told them, and maybe it's appropriate for the child to know about an upcoming hearing, but it may also dictate sort of what you need to do as that child's guardian ad litem to explain kind of what a hearing is like, and what are the potential outcomes of a hearing, and to say, well, I will plan to talk with you at 4 p.m. on Thursday, and I'll tell you what happened at the hearing. It may be that you have a parent who could do the same thing in an appropriate way, but that you may need to be that resource for a child.
So in addition to the information you'll gather throughout your investigation, there are some important resources that you should be aware of, and you can see a court contact sheet about how to access some of this information in tab 6, should be on the disc. So you could have home study reports and psychological or psychiatric evaluations. There might be interactive assessments of the parents and the child, or the caregivers and the child, and the supervised visitation center could be involved in a case, and if so, they might have documentation about what's happening during each of the supervised visits. There's also the multi-door dispute resolution center. That's where, through the court system, parties are able to participate in a formal mediation process free of charge. And there might be the possibility of parenting coordination, although at this point in time there is not a sort of court-sponsored parenting coordination program. And so parenting coordination services are often fairly pricey. So if this is something in your case, it's probably being done pro bono, or perhaps you're working with the parties to try and find a pro bono resource for parenting coordination. But all of these documents are things that, or information that could already be in existence that you want to access for your investigation, but they're also resources and services that you might want to recommend that the parties participate in for the purposes of helping to complete your investigation. So if you think that there could be mental health issues concerning either your client or one or both of the parties. Perhaps you'd like the court to order a mental health evaluation or a psychological evaluation. You should know that a home study is required before the court can order those evaluations. So the home study would happen first. And that's gonna allow someone from, it's called the Court Social Services Office. So with the home study, someone from that office is going to visit the homes of the parties in the case. They'll usually do a general description of the home itself. They'll typically sort of take a look in the kitchen, make sure there's appropriate food and things like that. They'll also do some basic background searches on the party, and then anyone that lives in the party's home that's over 18, they'll talk to the party about the social history of the case to get a sense of what that party thinks is happening and what the party thinks should happen. And when appropriate, they'll also talk to the child and sometimes get a sense from the child what custody arrangement the child is looking for in the case. And it could also involve some description of the interaction between a parent and a child. So the home studies can provide some pretty helpful basic information, and you might decide to use those documents in the case, but it's important to know that just because a home study has been done or could be done, it doesn't mean that you shouldn't also visit a home. It doesn't mean that you shouldn't also try to observe interactions and things like that. But these are all possible resources that can be helpful in your investigation, and also that might be used at trial if the case doesn't settle either through mediation or through a less formal settlement process.
So these three documents that Marissa just talked about, the home study, psychological or psychiatric assessments, and interactive assessments, are made upon request. So the GAL, often we will make a motion for these assessments. And they are performed, Court Social Services does the home study. It usually takes about 8 weeks to get a home study done. And then thereafter, a psychological evaluation or interactive assessments will take at least another month. So when you are motioning for one of these services, it is important to kind of keep in mind the timeline. Do you think it's imperative that this case go to trial in a month? Well, if that's the case, then you're not going to ask for this information. But if you have a trial date set in a month and you don't have any real evidence about the parties, but you speculate that there are mental health issues, then maybe you are motioning for these evaluations and asking to continue the trial date. So just, think about timing for some of these requests. Yes?
On that note, is there a typical timeline from when you would get the appointment to when the trial is?
So the question was, is there a typical timeline from when you are appointed to when you are going to trial? No, there's not a typical timeline. Sometimes we will get a referral and it says trial is in 6 weeks. There's no pretrial hearing and the court just wants a guardian ad litem to help at trial because the parties are unrepresented and the judge needs to make some sense of the evidence that's going to be put forward. Other times, there's no trial date set yet. It may be that the home study was conducted and the home study officer said that, recommended to the judge that the judge appoint a guardian ad litem. So it could just be the very beginning of things. It really varies. The home study and these other evaluations do not go into the court file at the clerk's office. So, when you get that initial appointment, you are going and getting a copy of the court file. You should not find these documents in there because they contain very personal information and domestic relations cases are open to the public. So you can call Court Social Services or the Assessment Center to try to get a copy once you're appointed to the case, or you can call Chambers and request those documents. Often what happens is that the court, if they're done just before a hearing, the court will hand the documents out at the upcoming hearing for everyone's review. Yes?
Are the parents given copies of the home studies and the psych evals and?
So they're often given copies of them at the hearing.
Oh, so
but
when you
not
said that, it was,
before.
they would, okay.
Yeah, not beforehand.
I think sometimes the assessment center will send each parent a copy of their own evaluation, and then the court may decide, usually upon someone's request, to give the opposite parties copies of the other side's evaluations. But a lot of times the information gets dispersed from the court directly.
On the hearing date, you're saying?
On a hearing date. Yeah. And in order to get any of these documents in, at trial, you need to have the author of those reports come to testify. Sometimes you could get the parties to stipulate to the admission of the evaluations, more often than not, oddly, but otherwise you need to have a witness, the author of the reports, come in. And often you want that, right? Because probably there's helpful information pertaining to the child's best interest in these evaluations, and it'd be great to have an expert talk about some of them. The Supervised Visitation Center is available in all of our cases. There has to be basically a finding that unsupervised visits would be harmful to the child in order for there to be supervised visitation. Some of the circumstances where supervised visitation through this center is appropriate would be if there's an active and ongoing substance abuse problem with the party, or there's physical abuse to the child, that there's a risk of that. Are there other circumstances that you could think of?
Sometimes, I don't think it's very common, but sometimes you'll have a child who's just not very familiar with the parent for various reasons. Sometimes it's because that parent just wasn't around. Other times it's because another parent was denying access. So the Supervised Visitation Center isn't the only way to have supervised visits. There are times when the parties can agree to a third party, usually a neutral third party, that can supervise the visits. But sometimes the Supervised Visitation Center is used for very young children that are just not familiar with the party. But I would just sort of mention that supervised visits don't have to be sort of permanent and ongoing. So if there are certain issues that were a problem but get resolved, perhaps someone may want to make a recommendation, perhaps the guardian ad litem, that supervised visits be discontinued. Because it is a very unnatural environment, and there's just, given the size of the rooms, there's just no way that third party isn't in some way impacting the way that a parent or a caregiver and the child are interacting. And sometimes that's what you want, because there are a lot of very serious concerns about what may go on if that third party wasn't there. But other times, like where you're just trying to give the child an opportunity to become more comfortable with someone, you want to think about when supervised visits should be phased out and how.
Are there any types of cases that a supervised visitation center won't supervise? For instance, if one party is on the sex offender registry, do they allow victim supervised visitations?
To my knowledge, that's not sort of a blanket reason to reject a case. I think they may not supervise visits for children over a certain age, but I'm not 100% sure about that.
So 2 additional points about the Supervised Visitation Center. The center can be used for drop-offs and pickups. So where a visit doesn't actually need to be supervised, but the exchange does, that can be facilitated through the visitation center. And you would motion the court to ask for such a thing, or the parties may have done that. Is there a question?
I heard recently that the supervised visitation center is no longer doing it.
Well, so we just got news that the Supervised Visitation Center may not be doing those kinds of exchanges. I'm not aware of that, but certainly we'll look into it. Hopefully that's not the case. There used to be a private organization in the community that also did this service, but that is no longer being funded. So there are limited options for a supervised visitation center. At the supervised visitation center, they take notes on if they're doing exchanges still. They take notes on the exchange, like did the parties appear timely? How did the child appear? Did they, they'll talk maybe about the interaction upon the child seeing the second party. And if there's actually a visitation happening, they will also write some general notes about the visitation. The center keeps those records. You can have access to those records. You have to call and request them. You could also subpoena them. They're not generally very helpful. In fact, the notes are usually pretty vague, but they could come in as business records if you have someone from the social worker who observed the visits come in and testify to them. And obviously they're good for reminders to kind of jog that person's memory about the visit and work on their testimony. Mediation can be a very, very valuable tool in our cases. It's available at any point. So, most often we are trying to craft a sustainable custody agreement that's in the best interest of the child, and that can really happen at any point. Like, maybe the parties are ready to kind of stop feuding and they'll sit down at the table and it's the morning of trial. Sometimes the court will give you a pass and you can go do that. It's always available as a resource and can be very useful. So those duties of investigation are ongoing and need to happen at every stage of the case. Just a very simplistic example, when you get the case, you're going to do a check for criminal and domestic violence records. When you go to trial 6 months later, you need to do another check for those criminal and domestic violence records. Obviously, these cases are so interesting because they are constantly evolving. They're not a criminal case where there was this one act that happened and you move on and you're putting on evidence about that. These cases, it's about a child and they're growing and developing and things are happening in the parties' lives. So you have to continually investigate. You can engage in discovery. With pro se individuals, it's often not very useful. So I often talk with pro bono folks about just gauging whether the cost-benefit analysis. If the parties have counsel, they may seek to depose the other parties, and you should certainly go and attend those depositions. It can you'll get some useful information, maybe. As we said, you're establishing a relationship with your child client and the adults in the child's life. Sometimes the adults will get angry at you because you've taken a temporary or pendente lite position and it's not in their favor. Or they think they should have more access to the child than you took the position of and that the court ordered. You still need to keep trying to maintain that relationship. At the end of the day, you're trying to craft that sustainable agreement, and if you don't have a good relationship, it's going to be very difficult to do that. And the court would much prefer that the parties, with the help of the GAL, come to an agreement than to issue a decision after trial. The court wants to make a decision that is reasonable, that the parties are able to follow, and often that is what the parties can come up with. Again, you're always staying apprised of those other court proceedings, particularly the civil protection order cases. That's very common that in the course of a custody case, a civil protection order matter will arise. And you'll hear later when Diane talks with you about the law regarding custody cases, But if there's a finding of an intra-family offense, the presumption of joint custody no longer exists. So in DC, we have this presumption that parents share equal rights. And if there's a finding of an intra-family offense, that no longer exists. So very common that we will see these cases happen at the same time, and they will affect one another. So your responsibility is to expedite the proceedings if necessary. If you think it is in the child's best interest to try to move things along, to try to get trial more quickly, then you should do so. What we know is that there's a lot of harm done to kids during the Competency Litem phase of these cases. They know about the cases. It's emotionally taxing. It distracts from their learning and growing, and so it is often appropriate to try to expedite the proceedings. Although you're not a mediator on the case, you should participate in mediation, and you can certainly initiate kind of negotiations and shuttle diplomacy and trying to come to agreement and common ground, and you're doing that constantly. You're filing motions, and ultimately, again, you're taking a position based on the child's best interest about whether the child should testify. So it's not uncommon for parties to list the child or children as witnesses. We generally think that's a pretty bad idea. For the most part, kids should not be put in the middle of these custody battles. And the reason there's a GAL is because they're probably pretty acrimonious. And it's tough for kids. We did have one case where we had, it was a motion to modify that the mom had filed regarding the grandmother continuing to have custody of a 17-year-old girl. And this 17-year-old girl had had it with her mom, and she wanted to testify. And she wanted to get, well, she didn't know this, but she wanted to get mom's motion to modify dismissed because there were no substantial and material changes in circumstances. And so we did put her on to testify. But the very rare circumstances, you'll be asked to take a position on that, and you should be, if you're opposing it, you should be filing motions to stop that. And Marissa will talk to you more about that later when we talk about evidentiary issues.
So at the point where you know you're going to trial, you'll want to start preparing early. And you'll need to plan to call witnesses and enter exhibits that are going to support whatever position you're taking at trial. Sometimes the judge is automatically going to set a pretrial date, and before that pretrial date, you and the parties will list out all of the witnesses each person intends to call, any exhibits each person intends to use. You'll have an opportunity to raise objections to any documents or witnesses, based on the rules of evidence as they're applied in the District of Columbia. But sometimes the judge will not have a formal pretrial process. If you think you can manage it, I don't think there's anything to stop you from doing a pretrial statement on your own and filing it with the court. But you'll want to sort of be on top of the case pretrial. You'll want to be talking with the other parties, even if it's through an informal process about what evidence they intend to use. You'll want to have them give you copies of their exhibits so that you're prepared at trial. You'll want to talk to their witnesses that they may plan to call, as well as prepare all of your witnesses to get in any testimony that you want the court to consider. You should subpoena your witnesses. I've not seen a judge hold anyone in contempt for their failure to appear under a subpoena. However, if you have a witness that you plan to call that doesn't show up, the best way that you can make the court aware that this delay was not part of your sort of lack of preparation is to be able to show that you actually subpoenaed that witness. So it's definitely a good idea to subpoena witnesses, no matter how many of them tell you, oh, I'll definitely be there. You can do it in a friendly way. You don't have to surprise them. You can schedule a time to have your investigator or paralegal meet them and serve them, but it is a best practice to just go ahead and do the subpoenas. And you'll want to prepare your witnesses for their testimony, both the sort of substance of their testimony, the fact that they may be cross-examined. You want them to be prepared for that. But if you have a witness that has not testified in a case before, you'll want to talk to them about what the setup of the courtroom is like, where the judge will be sitting, where you'll be standing or sitting in relation to them as you're asking questions, because you want it to be as least stressful for them as possible. And like Rebecca mentioned, settlement is always a possibility, so you never want to rule out the possibility of reaching some agreement before trial, even at trial or in the middle of trial. All of those things has happened. So a lot of times you'll be simultaneously trying to broker agreements and settlements and preparing for trial at the same time. As Rebecca mentioned, we'll talk about this in a little bit more detail later, but it is the GL's duty to minimize any adverse consequences to the client if they're going to be testifying in the case. So if the client is to meet with the judge or to testify, you'll also want to take the time to prepare the child for the setup of the courtroom, talk to them about the judge, the type of information that the judge might be talking to the child about, if it's going to be an in-camera interview. You just want to minimize any stress or anxiety that might come from a child testifying. But like we said before, we're going to talk to you a lot about how you can avoid this altogether by working to not have the child testify if it can be at all avoided.
Okay. So at the close of trial, the court may ask, and we will often volunteer, proposed findings of fact and conclusions of law. The court is required to issue a final written custody order, and so this kind of will help with the process. And, you know, we will have taken the most thorough notes at trial and have the best sense of the evidence, so we will often submit those to chambers, and the court is grateful for them. And obviously you're copying the parties when you're submitting that. The Domestic Relations Rule 101E4 indicates that a GAL's representation, as with any other party's representation, really ends 30 days after the entrance of a final order. So, you know, what we will do after we get a final order is talk with the child about the end of the representation and what that means, and if appropriate, about the custody order that was issued. And then, you know, we will consider filing a precipice to indicate the termination of our adherence. So those are sort of the end of case issues. And all of this, the pro bono CGAL checklist, which is in this manual at tab 12, provides kind of an overview of this basic information. Yes.
You mentioned depositions. Is a GAL able to depose the parties or others?
So the question was whether a GAL is able to depose parties. There's certainly nothing prohibiting a GAL from doing that. The GAL is to have the rights of a party and to participate in the litigation. The question is whether deposing a party would antagonize the party or the GAL's relationship with that party. So that's an important consideration. Okay, so now we are going to turn to cultural competence. Thanks. And normally you wouldn't have to hear so much from me. You'd be hearing from Nancy, but okay. So it's important to consider the context of your work on custody, guardian ad litem cases. So we're going to talk some about sort of the case realities and the cultural competence that we ask that you carry into your work as a custody, guardian ad litem, or any pro bono work that you are doing. Why it matters for custody guardians ad litem. as you've heard from getting an overview of the work of the CGAL, you are really being exposed to and evaluating families. You are making an assessment of a child's best interests and really getting to know families. And I think it's important to remember that culture plays into the way you perceive things and the way that people behave. And so you need to have a sense of the families that you will be working with. And I think that cultural competency means that you're not ignoring the fact that you may have a different sort of set of norms and different culture from the folks on your cases. But it's kind of acknowledging that and checking that as you proceed through your work. Culture is a social and moral code of conduct. It can include a group's shared experiences or commonalities. It's a social and moral ethos. And it can be based on various things. So someone's ethnicity, race, gender, or other factors such as economic status, marital status, and other sort of where you live and how you appreciate life. And so it really varies, and you have to think about kind of the individual families that you are working with. And how do we use culture? Well, it informs our view of the world. It's our lens on our experience, and it's our clients and the parties on our cases. It's how they perceive the world as well. And it's how we attach meaning to the experiences that we have. It is also how we judge others' behavior. And what happens is that we may react not to the person who is acting in front of us, but to experiences that we've had with others who have the same kind of characteristics. So cultural competency doesn't mean that we pretend that the differences amongst us don't exist. But it means that we are constantly kind of assessing the other people's cultures, and we're assessing how our own culture or experiences affect our perception of the case. And realizing that, it may even be an unconscious process. And so we need to think very carefully and to be mindful of how our judgment may be influenced in the course of our work. So where might this come into play? And as I said, in CGL cases, you are becoming very intimately involved in folks' lives. And so, your own beliefs may impact your view on what is the right family structure, and what about the parent's personal backgrounds? What about if a parent has a criminal history? Or maybe it's about you think, you were raised by parents who were 30 years older than you, and so, maybe you question whether an 18-year-old could be a good parent. Or it's in the relationships that folks choose to have, different disciplinary choices, or financial decisions, and the priorities that parties may put on certain life choices, or they're choosing not to be as involved in their child's education than that you would be, or that your parents were in yours. So it's just to be very aware of where this might come into play, and all the different facets of it. So here are some examples of incompetence. And I think they're kind of self-explanatory, and based on what we've talked about already. You don't want to use your own self as a model for how things should be in your case. You need to look at it really independently. So it's also important for you to have a sense of who your child client is, and you're going to assess that on an individual basis. But to give you a sense of kind of the context of our cases. So you will learn about the individual families. You will learn about this child, and you will get a sense of the family and the family dynamics. And you should not make assumptions about what you see. There are very complex custody issues in these cases, and it's not because of the socioeconomic status necessarily. We get referrals from various different kinds of families and different backgrounds. Many of our cases do involve lower income folks, but they're not all like that. And that may not shape the dynamic in the family. The other factor to think about is the different problems that our clients and families may be experiencing. The custody case alone can be a major stressor. And if you're involved, that probably means that there is some degree of conflict, that an easy resolution to the case didn't happen before your involvement. So the child and the parties that's a real stressor. But there may be many other stressors that are impacting the individual's behavior or perception of their experiences. And these are just sort of to think about all of these factors. There may be mental health issues that are coming into play. It may be that the child doesn't have an adequate education or appropriate education, and so the parents are dealing with the child being thrown out of school on a regular basis, and that can be stressful, and that dominoes into the parent having to take unpaid leave from work, and then that becomes a problem in terms of how will you pay your rent if you have to take unpaid leave from work. There are just many factors to consider, and so when you're thinking about your work on this custody case, you can't just think about sort of the custodial arrangement on its own. You have to think about the other factors and the realities. Poverty impacts many DC families, and it is prevalent in DC. And it may be a factor in our case, in the cases that you're working on. And here are just some statistics about poverty in DC. Family structure. Many of the family structures that you will see are not necessarily traditional. There are many grandparent-led households in the District of Columbia, and that's it's almost a norm in our cases. And so it's just something to keep in mind that, the child's primary caretaker may be someone who you would never have thought of as playing such an integral role in their lives. And so you need to just be open to the idea that there may be a different family structure at play. Health issues can be a major stressor as well. 60% of DC children are enrolled in Medicaid, so they are receiving some services. There may be a question about the quality of those services that folks are receiving. And those children don't receive adequate mental health services, and that's a serious and stark reality in DC, and so it's something to keep in mind. And that may be something that you will have to work closely with the parents on to get the child appropriate mental health services. There may also be problems in the educational system. That's a real reality in the District of Columbia. 58% of DC students graduate high school. That's a pretty low number. And there's a huge racial achievement gap in the District of Columbia. So how do you translate client and family realities into cultural competency? You're being self-aware and consider what preconceptions you bring to your advocacy, constantly checking your own behavior and own position. Listen and watch. Think about the different ways that people are communicating with you, both verbal and nonverbal. Learn and ask why if you don't understand. So don't assume that there's a certain reason behind a parent's action, but ask why so that you have an understanding of that. You're getting to know the individuals on your cases, so avoid working with stereotypes. Don't judge, so think about the different possibilities and different meanings to certain behaviors or circumstances. And respect. So recognize that your own values and morals aren't necessarily the right ones, or not the right ones for the families that you are working with. And talk about it. Talk with your peers. Call us and talk with a mentor about some of the different cultural values or the differences that you are seeing. And some of our cases even raise that there are cultural clashes that bring about the custody conflict. And that also can pose an interesting and challenging dynamic. And you also have to reflect on your own actions and experiences and the choices that you are making on your cases. And look out for those red flags of your own cultural incompetence. It's just a very important consideration as you're becoming so involved in other people's families. And the custody of a child is something that pulls tremendously on people's heartstrings. I mean, people care more about their kids than most other things. And so you have to be very mindful. You have a powerful role to play as the guardian ad litem in a custody case, and so you should do it cautiously and in a culturally competent way.